you need to charge. It doesn't seem to me as if you're trying to flee or be a flight risk. You're just staying at your brother's house. And I have the address of the other location in Warren, as well as an updated phone number. We will provide that to the tether office as well. Ms. W, did you provide that information to the tether unit?
No, I didn't. They just said I was lying when I told them my tether died and I tried to fix the issue. So they just took me in.
Okay, so you'll be released. I'm going to send an order over now, and you are to still have a tether, and you are allowed to. So first of all, the bond conditions that I have in the ROA, it doesn't say anything about house arrest. It says no contact with the complaining witness and no weapon. So Ms. W, were you supposed to stay at Genesis house only?
No, like they said I couldn't verify my address, so I had to stay there until I verified an address.
Okay, so we'll send over those two addresses, and no contact with the complaining witness, okay?
Okay.
Anything else, Attorney Anderson?
No, just I reminded Ms. LB that she's got her preliminary examination before Your Honor on Thursday, the 9th at 9:30 in person.
Okay.
You said Ms. LB?
Yeah, so I'm good to go?
Yes, we have to send the information over. The clerk is going to do it as soon as we get off the record.
Okay, thank you.
February 9th, 9:30, 36th District Court in person, okay?
9:30?
Yes.
Yes.
Okay.
All right. You have a good rest of your day, Ms. O.
You too.
Thank you very much, Your Honor.
Thank you.
Thanks.
If you're on the record, that the people of the state of Michigan versus Jerry Waver Pitts Senior, Mr. Pitts is charged with 1 count of police officer fleeing, 3rd-degree vehicle code, and this is case 2260976. Today is the date set for preliminary examination appearances.
Good morning, Your Honor. Daniela Parrish on behalf of the people, P85495.
And good morning, Your Honor. Sanford Shulman, P43230, appearing on behalf of Jerry Pitts, who is standing behind me to my right.
And Mr. Pitts, can you state your full name for the record, please?
Jerry DeQuavius Pitts Senior.
Okay, thank you. Good morning. And how are we moving forward today?
Your Honor, please the time and date scheduled for the in-person preliminary exam. We are present and we have reviewed the discovery. It's my understanding Mr. Pitts wishes to waive the statutory right to a preliminary exam. People concur. We've tendered to the court and executed the waiver.
Is that correct, Mr. Pitts?
Yes, ma'am.
And do you understand that if you were to hold an exam or demand your exam, that the people would have to prove at the probable cause standard, not beyond a reasonable doubt, probable cause standard, that the crime was committed in the city of Detroit and that you probably committed that crime? Do you understand that? Okay, and make sure you speak up for the court reporter.
Yes, Your Honor.
And you understand that waiving your preliminary exam means that the prosecutor will not have to call you witness today and you'll be sent over to 3rd Circuit Court for your next court date for an arraignment of the information.
Yes, Your Honor.
Okay. Couple more questions. Did anyone force you or threaten you to waive your preliminary exam today?
No, Your Honor.
Okay, I find your waiver to be freely, understandingly, and voluntarily given. Your arraignment on the information will be February 16th, Frank Murphy Hall of Justice at 9 o'clock, okay?
Yes, ma'am.
Anything else?
No, Your Honor, thank you.
All right, thank you. You have a good day.
Madam Clerk, have you received any phone calls for any attorneys?
No.
Okay, thank you.
anybody feel like making phone.
It was 10 o'clock. Oh, she still have a check in on it.
Okay, and yourself.
You know, this attorney on at 10 o'clock when you see him. Yeah,
No,
me either.
probably my face though.
He's married here. Yeah, multiple officers here.
Thank you.
Interrogation, standing, OIC, POs.
Thank you.
You're welcome. But no attorney and no defendant. That makes a difference.
All right, what do I need to fill out for?
Nobody.
Attorney Watts, good morning.
Good morning, Your Honor. I'm calling about the exam tomorrow for Jonathan Young. That's going to be a waiver, not an exam.
Thank you.
And so are we able to, can we do it by Zoom? Would we be able to do it today or do we have to wait till tomorrow?
We can do it today if the prosecutor's okay with it.
Let me get the on then, Your Honor.
Okay. And the prosecutor's in the hallway. What's your client's name again?
Jonathan Young.
Okay, we'll get his file. Okay, we're on the record as the people of the state of Michigan versus Brandon Evans or Devin Lee. Case number 2260935. Mr. Lee is charged with count 1, weapons, dangerous weapons, miscellaneous. Count 2, operating with a high VAC. This is a habitual offender, third offense notice. Today's date set for preliminary examination appearances.
Good morning, Your Honor. Daniela Parrish on behalf of the people, PA 5495.
Good morning, Your Honor. Alexandra Cheryl with Neighborhood Defender Services Detroit, 85948, appearing on behalf of Mr. Lee.
And Mr. Lee, can you state your full name for the record, please?
Devin Lee.
Thank you. And how are we proceeding today?
Your Honor, at this point, we are waiting the exam.
Okay. All right, Mr. Lee, I'm gonna ask you a couple questions, okay?
Yes.
You understand that it's your statutory right to have a preliminary.
Yes.
Okay, you understand that the prosecutor, if you were to hold that exam, would have to prove at the probable cause standard, not beyond a reasonable doubt, but at the probable cause that the crime was committed in the city of Detroit and that you probably committed that crime.
Yes.
Okay, and you understand by waiving your exam, preliminary exam today, that the prosecutor does not have to do that.
Yes.
And that you'll be bound over to Third Circuit Court for an arraignment on the charges I just read.
Yes.
And knowing all that information, is it still your wish to waive your preliminary exam?
Yes.
Okay, did anyone force you or threaten you to waive your preliminary exam? Did anyone promise you to waive your preliminary exam? Okay, I find your waiver to be freely, understandingly, and voluntarily given, so I will have you bound over to Third Circuit Court, Frank Murphy Hall of Justice. For your arraignment on the information, the date will be February 16th at 9:05 p.m. Okay? Anything else from the party? Mr. Lee, you have a question about the date?
No.
Unless it's something that needs to go on the record.
That's something that I'm a third habitual. I don't have, that's what I was saying. I'm a.
I can explain my side.
Okay. All right, you have a good day.
Thank you.
Thank you.
I just need 30 seconds to pull that one up. Maybe just.
Okay. Attorney Taylor Coleman, good morning.
Good morning, Your Honor.
How you doing today?
Oh, it's another day. I'm blessed. Thank you. I hope you in the court are also. I am in trial in Judge Q6.
Okay, well, we won't take up too much time. Mr. Massey, your client, do you know where your client or LaShawn Massey is?
Actually, I'm asking to waive his appearance for the PCC. He did appear at the previous date. He asked me if it was tomorrow. I did not have it. Yesterday, he texted me. I did not have it on our docket, and because I was in trial, didn't check. But just to ask the court to waive his appearance, we are asking to set this matter for exam. I'm texting him now. See if he can zoom in, but we are asking for this matter to be set for exam. I did receive discovery. I have not been able to check in regards to the video. But we are.
Okay, let me call the case. This is case 2161451, the people of the state of Michigan versus LaShawn Chris Massey. Mr. Massey is charged with 1 count of weapons carrying concealed. Today's the day set for probable cause conference appearances.
Good morning, Your Honor. Danielle Parrish on behalf of the people, P85495.
Good morning, Your Honor, and thanks the court for calling me. Delisha Taylor Coleman, P56278, on behalf of LaShawn Massey. We are asking the court to waive his appearance for this PCC. I gave him misinformation, and I do apologize. I am trying to text him right now, zoom in, but we are just requesting a preliminary exam date in this matter, and we have discussed that, Mr. Massey and I.
Okay, I will waive his presence, since you have any contact with your client. So I have, February 22nd, 23rd, and 24th open for date.
Let's do the 23rd, Your Honor.
Okay, Mr. Massey, you have logged in. Can you state your name for the record, please?
LaShawn Chris Massey.
And Mr. Massey, all we've done so far is just discuss the date for your preliminary examination, okay?
All right.
You said the 22nd, Taylor Coleman?
23rd, Your Honor.
23rd, okay. I have 8:30, 9 o'clock, 9:30.
9:30, please.
Okay, anything else?
That would be in person. If there's an issue with the discovery, I'll contact the prosecutor in the court before that date, Your Honor.
Okay. All right, Mr. Massey, so I will see you on exam date, February 23rd at 9:30, in person.
Thank
Okay.
you.
All right, you all have a good day.
Take care.
Mr. Young is here now, Your Honor.
Actually, let's call, we have five. Are you ready?
Oh. I jumped onto the nasty one before.
One moment. Mr. Campbell, while we're waiting. Oh, Miss Campbell, excuse me. Good morning.
You're fine. Good morning.
What are you here for today?
I am actually here for a landlord tenant hearing.
That would be my brother's courtroom. That's 533 today. Courtroom 533.
Oh, gotcha. Okay, I apologize. Thank you so much.
You're welcome. We're just getting some information. The prosecutor has to upload something. We can get started.
Yo, check in on the phone.
Here's the file back, Your Honor. Thank you.
Maybe you should put,
Hold on.
okay, what you got on here? Maybe you should put a one.
Okay, we are on the record of the people of the state of Michigan versus Jonathan Young, case 2355015. Mr. Young is charged with count 1, weapons, firearms, possession by a felon, count 2, weapons carrying concealed, count 3, weapons, felony firearm. He is an habitual offender, third offense notice. Mr. Young's preliminary exam is set for tomorrow at 10:00 a.m. Appearances.
Good morning, Your Honor. Daniela Parrish on behalf of the people, PA 5495.
And good morning, Your Honor. Coral Watt appearing on behalf of Mr. Young, P41508. Could you state your name, Mr. Young?
Yeah, this is Jonathan Young.
Thank you. Is it correct, Attorney Watt, that your client would like to waive his exam for tomorrow?
Yes, Your Honor. I'm sorry. Yes.
Okay, and Mr. Young, can you turn your camera on?
Yes.
There we go, okay. So, Mr. Young, I'm gonna ask you a series of questions, okay?
Okay.
First, is this your wish to waive your preliminary exam?
Yes.
Okay, and do you understand that you have a right to a preliminary exam?
Yes.
And that if the prosecutor were to hold the preliminary exam that's scheduled for tomorrow, they would have to prove at the probable cause standard, which is much lower than the reasonable, beyond a reasonable doubt, but still a probable cause standard that the crimes that I just read out, the charges were committed in the city of Detroit and they were probably committed by you. You understand that?
Yes.
And that by waiving your preliminary exam, that means that the prosecutor does not have to do that and you'll be sent over to Third Circuit Court, Frank Murphy Hall of Justice, for your arraignment on the information. You understand that?
Yes.
And knowing that information, do you still wish to waive your preliminary exam?
Yes.
Okay, did anyone force you or threaten you to waive your exam today?
No, ma'am.
And did anyone promise you anything in exchange for your waiver?
No, ma'am.
Okay, I find your waiver to be freely, understandingly, and voluntarily given. So I will have you bound over to Third Circuit Court. Your arraignment on the information will be February 16th at 9:00 a.m. Frank Murphy Hall of Justice, okay?
Okay.
Thank you, Your Honor. Nothing further, Your Honor. February 16th. Thank you.
I appreciate you calling in a day early. That helps us out for tomorrow.
Oh, no problem, Your Honor. Have a great day.
All as well. You're all set, Mr. Young. Everybody else, Mr. Hall? Here on the record is the people of the state of Michigan versus Sean Jamar Hall, case number 2258261. Mr. Hall is defendant 2 on this case and charged with count 8, accessory after effect to a felony. This is the commission of a felony with a motor vehicle advisory. Today's the day set for a preliminary examination appearances.
Good morning, Your Honor. Daniela Parrish on behalf of the people, P 85495.
Your Honor, may I please this honor before Larry Polk on behalf of Sean Hall, who stands to my immediate right. Mr. Hall, would you state your name for the record, please? Sean Jamar Hall.
Good morning, everybody.
Judge, today is the day time set for preliminary exam. I've had discussion with my client. I've explained to him the nature of a preliminary exam with people. The people must demonstrate his probable cause of crime. Probable cause he had some involvement in that alleged crime. With that knowledge, he's elected to waive the preliminary exam. Send this matter to Frank Worthing Hall of Justice for further proceedings. Is that correct, Mr. Hall?
Yes, sir.
And you're doing this based upon your own free will and understanding of what this hearing is about?
Yes, sir.
Okay, thank you, Attorney Pope. I find your waiver to be freely, understandingly, and voluntarily given. So with that, I will have you bound over to Frank Worthing Hall of Justice, 3rd Circuit Court, for an arraignment on the information date of February 16th at 9:00 a.m. That concludes this matter.
Okay. Madam Clerk and Judge. Mr. Polk is assigned to the Smith matter, and he's not familiar with the second case, so he needs to speak with his client.
The second case,
It's 2 cases for Smith. One says contempt of court and the
that's
other.
the complaint, one of the witnesses.
Oh, it has
So we
his
had a
name
witness
on it.
detainer, and yesterday, he was actually picked up.
Oh, I wasn't.
So the second case is not your client, it's Mr. McGowan. who we filed.
Oh, okay.
He's here. We
Yeah,
have,
he is
he
here.
locked up yesterday. I let him out on personal bond, he showed up.
Oh, that explains a lot.
Yeah, it was a little.
Okay. Thank you, Judge.
Okay. Thank you.
You just give him to speak.
Oh, no, I'm going down there to speak to him. Yeah.
To the gentleman with the I'm sorry, with the Samsung. To the woman with the iPhone, with the camera off, can you state your name, please?
Angel Splunge.
Say your last name again.
Splunge, SPLUNGE.
Okay, what are you here for today, Ms. Barnes?
Court proceedings for my rent payments.
Okay, so my brother is also Judge Sabree, so you should be in courtroom 533 for landlord tenant. This is a felony docket.
You said 533?
Yes.
Okay, thank you. I'm sorry.
No, you're fine. Have a good day.
You too.
Hello,
Yes, sir. What is your name?
Eric Buckley.
And Mr. Buckley, okay, we took care of your case this morning. Let's see what happened. I believe we just set it for a preliminary exam date.
Oh, Judge, he's adjourned, he's 2-9 at 8:35.
Why would-
That was Mr. O.
Looks Fine.
Attorney O.
Oh, yes. So, Mr. Buckley, we adjourned your case because you weren't here. Your case was at 9:30 this morning.
Okay, I just got the letter, so I barely caught it. So I just want to make sure I had no warrant out. And what is the next court date?
So first, I didn't issue a warrant.
You didn't?
For your arrest. I did not.
Thank you.
You're welcome. So your next court date is February 9th.
February 9th.
It will be another probable cause conference at 8:30 a.m. on Zoom.
Okay.
And
Same
make sure you
time.
call Mr. O, your lawyer, talk to him about your case, so that when you call in the HR, you can go ahead and get moving, okay?
Thank you. I appreciate your help.
You're welcome. Have a good day.
You too.
What is going on?
at Sonora's iPhone. Sonora's iPhone, can you hear the court?
Yes,
This is a criminal court, ma'am. Do you have a criminal case?
no. This is Judge Sabree. Sabree,
Do you have a landlord tenant matter, ma'am?
yes.
Okay, you will be in front of Judge Adam Sabree, and the phone number for that courtroom, well, the Zoom number, would you like the Zoom number or the phone number, ma'am?
The Zoom number.
Sure, 360-533-0000.
Thank you.
You're welcome, thank you.
You're on the record as the people of the state of Michigan versus Martise Cartrell Smith. Case number 2257887. Mr. Smith is charged with count 1, assault with intent to murder. Count 2, assault with intent to do great bodily harm less than murder or by strangulation. Count 3, assault with a dangerous weapon, felony assault. Count 4, weapons, felony firearm. Count 5, weapons, felony firearm. And count 6, weapons, felony firearm. Today is the date set for a preliminary examination. Appearances.
Laura Gustafson on behalf of the people, P67104.
Your Honor, may it please this honorable court, Larry Pope on behalf of Martise Smith, who stands to my right and rear. My P number is 48164. Mr. Smith, state your name for the record.
Martise Smith.
And good morning, everyone.
Good morning.
And are both parties ready to proceed?
We are, Judge. We'd ask that there be a mutual order of sequestration. I see no one is in the court. Just for the record.
And no one is in the courtroom except for staff, attorney, the defendant, and officer in charge.
That's correct, Your Honor, and that's that, the officer in charge officer could all print out remain in the courtroom.
Is there an
No
objection?
objection.
Okay, with that, any other preliminary matters?
No, Your Honor.
Okay, go ahead and call your first witness.
I'd like to call at this time Sergeant Jelani Jones.
Court reporter, they-
Oh, you mean, but
yes. Call your first name, please. You swear to tell the truth, the whole truth, and nothing but the truth. Okay, have a seat. Make sure you speak up in the microphone.
Okay, thank you. Sergeant Jones, can you please state your name for the record?
Jelani Jones,
Thank you, sir. I see that you have something in your hand. What is that, sir?
this is the Department report.
Okay, sir, I'm just gonna ask that you not look at it until and unless you need to refresh your recollection.
Absolutely.
Thank you, sir. I am gonna take you back to May 31st, 2022. Did something happen that day that brings you to court?
Yes,
Okay. And can I ask, how are you employed, sir?
I am employed in City of Detroit, police sergeant for the City of Detroit now, about 22 years.
Thank you. And on that date of May 31st, 2022, were you working in your capacity as a police sergeant for the Detroit Police Department?
Yes, ma'am, I was.
Were you conducting surveillance or on the job on that day?
Yes, ma'am, I was.
Okay, and were you in the area of, if I can have a moment? Of 19431 Edinburgh in the city of Detroit, County of Wayne?
Yes,
Thank you. And what were you doing that day, sir?
I currently was working in a surveillance capacity. One of my scouts, 832 to be exact, had just had some fleeing suspects. And so I was canvassing the area in an undercover capacity to find those individuals.
All right. And so were you then canvassing the area in a vehicle, sir?
Yes, it was a unmarked undercover vehicle.
Okay, unmarked, sir?
Correct.
All right. Were you alone in that vehicle?
Yes, I was.
All right, so you would have been driving that vehicle?
Yes,
Were you parked or driving?
driving.
Okay. And did something happen that brings you to court?
Yes, while traveling east on Vassar,
Okay.
approaching Edinburgh, I saw an individual that may have matched the description of 832's fleeing suspect.
Okay.
So I went to the intersection of Edinburgh and Vassar
Okay.
to turn around. I conducted what's called a J turn, which means I briefly turned onto Edinburgh to back up, to go back west on Vassar.
Okay.
As I was pulling the car in reverse at the intersection of Vassar and Edinburgh, that's when I heard several shots and one impacted the front windshield of my car.
All right. And so at that point, you're in front of, and you're on Edinburgh?
I'm right in the intersection of Vassar and Edinburgh.
All right.
So I would say the front of my car is right at the intersection pointing northbound of Edinburgh.
Okay. And you heard about 4 or 5 shots, sir?
Correct.
4 or 5. And one took effect on your windshield?
Yes, ma'am.
Did it strike you?
No, it did not.
Okay. And what did you do once that shot took effect on your vehicle?
I, of course, retrieved my weapon. I tried to get into a cover position, trying to retreat from the area, and at which time, approximately 4 houses north on the west side.
Okay.
I believe that is it. On Edinburgh.
Okay.
Is where I saw a black male on the front porch retreating side of that location wearing a white shirt.
All right. Were there other individuals on that porch when you observed the black male with the white t-shirt retreat back into the location?
At that time, I was the only person I saw, and as well, it was no other houses or any individuals out, maybe because it was almost midnight. And that porch light was out, so therefore it's kind of brought my attention to the house.
Okay. Can I have a moment, Your Honor? Yes. May I approach the witness, Your Honor, with equal proposed exhibit 1? Yes. So I handed you a photograph. Can you describe that? Can you take a look at that photograph and tell me if you recognize what is being depicted on that photograph?
Yes, ma'am, this is the dwelling that the defendant ran into, and also the house that we subsequently later executed a search warrant.
Okay, and you just used the word defendant, that, can you describe who that person is that you're referring to as defendant? Do you see that person in the courtroom right now?
I believe it's the gentleman right there in the green jacket, Marquis Smith, from the loud mask on, but that appears to be.
Would you like us to take off our masks so that you can confirm whether or not that is identification?
Sure, that's fine.
Your Honor, may we take our masks off for just a brief moment so the witness can make an identification? Thank you.
That's correct.
Thank you. Okay, let the record reflect that the witness has identified the defendant, Marquis Smith, as the individual that he described as defendant who retreated to the house. Is that?
That's not his testimony, and so I asked that she has more foundational questions to represent. Can you justify that?
I'll restate the identification. Let the record reflect that the witness has identified the defendant. Any objection to that?
No, whatsoever.
Okay. This person that you observed in the courtroom, is this the same person that you observed retreating into the home?
This is the person who was recovered and matched the description of, when I returned back to the location, this individual, I was able to confirm was the person that ran into the house, once I returned.
Okay, and when you returned, so we'll get back to that, but when you returned back, was the person who was recovered wearing the white t-shirt?
Yes,
Was that similar to or the same white t-shirt you observed of the individual who retreated into the home?
yes, ma'am.
All right, and that photograph that I handed you, is that photograph the home you observed that person retreat into the home?
Yes, ma'am, the front door.
Your Honor, at this time, the people move to admit people's proposed exhibit number 1.
No objections, Judge.
Okay, it will be admitted. Thank you. Okay. All right, so I'm gonna go back to when you observed someone retreat into the home. What did you do once you observed that?
All right, once I made the observation, I returned. Of course, I notified dispatch, priority. Of course, after getting covered, I knew that, 1 block over, that 832 had individuals detained. So I retreated to them. I gave them, the description of the house and, of the suspect. And at that time, I went to the precinct to retrieve my gear that was needed and my marked vehicle that I needed to return back to the scene.
Okay, so you got yourself prepared and ready to enter the scene and investigate that scene?
Absolutely,
Okay, and did you return to the scene then?
I did.
Did you return to the scene or alone or with other officers?
When I returned to the scene, officers had the house secured, surrounded, and individuals were detained, including Mr. Smith.
Okay, and did you enter the home at any point?
Yes, once the search warrant was obtained, we did enter into the dwelling, and I assisted with the searching of the dwelling.
Okay, and did you recover any items while you assisted with the searching of the dwelling?
Yes, ma'am, I did. While searching the upstairs of the dwelling, it was a crawl space, and at which time I recovered a semi-automatic handgun. I don't have to remember, refresh my recollection what type, but it was just medium-sized, small frame handgun.
Okay, and you say that if you were to refresh your recollection with your report, you'd be able to identify specifics as to that gun?
Yes, ma'am.
Please do, sir.
It was a Taurus 9mm handgun. It was loaded. I did not count the magazine. I mean, count the amount of rounds in the magazine. It was loaded. That was located inside of the crawl space.
Okay. Mr. Cole? Your Honor, may I approach the witness with People's Proposed Exhibit number 2? Yeah. Thank you.
Thank you.
Sergeant Jones, I have handed you a photograph. Can you tell me what's depicted on that photograph?
Yes, it's to describe handgun with magazine still inserted. And it does have a familiar serial number, which reads TLP Tom Lincoln Ball 21473.
And is that the handgun that you observed and located when you were conducting your search of the house?
Yes, ma'am, it is.
That is the handgun you located in the crawl space of the house?
Yes, ma'am.
Your Honor, at this time, the people move to admit People's Proposed Exhibit number 2.
No different, Judge.
It'll be good. When you were conducting the search of the house, were there other individuals other than the defendant present? Civilians present? I can restate that question, it was messy. Were there other civilians detained at that location when you arrived on the scene?
Yes.
Okay. Did you or any other officer determine who lived at that house?
Yes, well, I did determine that the defendant, that was his residence.
How did you determine that, sir?
Per lien.
Per lien?
And I recovered mail there as well, I believe. But definitely it was mail that was there.
Your Honor, may the people approach the witness with People's Proposed Exhibits 3 and 4? Yes. Mr. Cole. I'm having you People's Proposed Exhibits 3 and 4. Can you take a look at those photos and tell me if those photos reflect items that you located or observed in the home when you were conducting your search?
Correct, these are two of several group of residents, occupants that were there, one of which very familiar DT, his name on.
That proposed is 3 or 4? 3.
Actually, 3 is a zoomed out copy of it, and I believe that it's a zoomed in copy.
But at this time, people would move to admit People's Proposed Exhibits 3 and 4.
Objection, Judge. No.
They were admitted. And so, Sergeant Jones, those items that are depicted in the photograph, do those photos have the defendant's name on them?
Yes, ma'am.
Or I should say, do those items of mail have the defendant's name on them?
Yes, ma'am.
Did they have the address of the home that you were searching in inside at the time on them?
I have to look at the other article. One had a Southfield address, which we also knew was one address of it as well. I can't really see the one that was zoomed out. Unfortunately.
But those items did have the defendant's name on them and were inside that home?
Yes, it is.
Okay. have nothing further for this witness, Your Honor.
John, you generated a report.
Sorry?
You generated a report.
Yes, sir.
Okay, now in this particular incident, you considered the complaint, right?
Correct.
Okay, and so are there any policies of the Detroit Police Department that dictate that you as a complainant cannot be involved directly in the investigation?
No,
You sure?
to my recollection.
Your recollection, okay, and you are, what's your title, you a sergeant?
Master Sergeant.
Master Sergeant.
Yes, sir.
And so in this incident, you were the individual that went inside of the location and assisted with the search of that location.
Correct.
And then you are the individual that finds and locates this weapon.
Correct.
Okay, and you are the individual that finds and locates this male.
No, sir. I don't believe so. I believe that was recovered somewhere else. It's just evidence within the case.
Okay.
Can't recall if I was alone with it. There were several individuals searching.
How many?
Several.
3?
Well, it was an execution team of probably 10 at that time. We had investigators on scene and everything.
What was the description of the individuals that you were looking for in that particular area?
To the best of my knowledge, I can't recall. They weren't, they were fleeing. So it was individuals, some young men, black males who fled from maybe 4 or 5 of them that fled from the officers.
4 or 5. Okay, and you're undercover, so you had to get some type of radio information about who you were looking for, correct?
Correct.
Okay, where does that information come from?
From the officers.
Okay, and is it direct to your radio, or does it go through dispatch?
At that time, we have a car radios, so it was direct from the officer
Okay.
to whoever was on that channel.
Car radios, are they recorded?
I believe so, yes.
And so you were provided with a description of these individuals that the other scout car was looking for.
Correct.
Okay, do you know if those individuals were running in and out of yards?
I don't know. I don't know. We never located them, to my belief.
Okay, you never located those individuals?
It was a group of individuals and half of the group ran. So I think this incident determined all of that effort to obtain them.
Sir, can you repeat that last
So
answer?
it was a large group that half of the group ran. And so the incident that occurred on Edinburgh with me, we had discontinued that activity for those individuals.
Fair to say you never saw anyone discharge a weapon?
I did not.
Never saw anyone with a weapon?
I did not.
And it's your testimony that there was only one person on that porch when you looked over there?
No, my testimony is I only saw the defendant running in the house.
Okay. So no one else was on the porch at that point?
Not that I can recall.
You saw.
Not that I can recall.
I don't have any additional questions, Judge.
No. No. Actually, strike that. I have one question. I apologize. The defendant that you've identified in this courtroom here does this defendant fit the description of the individuals that you were initially investigating?
No, the initial defendants were younger males. I believe they had dark clothes.
Okay. And the shots that were fired that you heard were in the proximity, in the space of this Edinburgh address.
Correct. The initial incident occurred 1 block west and initially even another block south. I was just doing the canvas of immediate, like a square of the initial. So just to see if those guys maybe had rested. Of course, if a person runs several blocks, I would be able to see them maybe, easing up. You don't see police officers around because I was in undercover capacity. And that's what I was doing, just circling the canvas and, see if I could see anybody who looked like they just got the drug.
And so your purpose of being there was to see if any individuals had run away from the scene of where that shooting had been reported?
Not the shooting, the fleeing individuals, right? There was no shooting at the time.
Okay, and the only shooting at that time is the shooting that involves the 4 or 5 shots that you heard and the one that took effect on your windshield.
Correct.
Thank you, nothing further.
Nothing else. Bjorn.
Okay. Mr. Jones, you can sit down, please. At this time, Your Honor, I'd like to call Evidence Tech Callahan. Good morning, sir. Can I have you state your name for the record?
Trevor Callahan.
Okay, and how are you employed, sir?
I'm an evidence technician for the Detroit Police Department.
And do you have a title?
Forensic technician.
Okay. And were you working your capacity as an evidence technician on May 31st, 2022?
Yes, I was.
And were you called to a location to conduct investigation or recover evidence on that date?
Yes, I was.
Were you called to a house at 19431 Edinburgh in the city of Detroit, County, Wayne, State of Michigan?
Yes.
Okay. And on that date, what were your duties?
On that day, I was in charge of doing photography for that scene, which was documenting all of the potential evidence and the scene in the house and the surrounding location at the time.
Okay. And I'm gonna hand you what are people's exhibits 1, 2, 3, and 4. Sir, did you take those photos?
Yes, I did.
And number 1, people's number 1, is that the home that you were searching and taking photographs at?
Yes, it is.
Okay. All right, I can have this one moment. Okay, I'm going to hand you what are people's proposed exhibits 5 through 10. And I'm just gonna let the record reflect that one of the people's exhibits is on the other side of another exhibit. So if you take a look at those items that are labeled people's 5 through 10. Are those photographs that you took, sir, on that date of May 31st, 2022 at the Edinburgh address?
Yes, they are.
Can you describe to me what those items are, or strike that? Do those photos accurately represent the items that you took photographs of on that date?
Yes, they do.
People move to admit people's proposed 5 through 10, Your Honor.
No objections, Judge.
Be admitted.
Thank you. Can you describe for us, for the record, what those items are?
So they are depicting placards, the first couple are depicting placards 1 through 4, which were 9mm cartridge casings that were located in like a rock area near the front porch of the residence.
Okay.
And then placard 5 is a fired bullet that was located on Edinburgh towards Vassar, south of the residence.
Okay. And that would have been actually in the street, a public street?
In the street, correct.
Okay, thank you. I'm gonna hand you people's proposed number 11. Can you take a look at that photo? Is that a photo that you again took on that date of May 31st, 2022 at the Edinburgh address?
Yes, I took that picture. It wasn't in front of the residence, but it was on an adjoining street near the residence.
Okay, and is that, and what is that a photo of, sir?
It's a photo of one of the individuals that were detained by the police prior to our arrival on the scene.
Okay, and does that photo accurately represent the scene and what you took a photo of on that date?
Yes, it does.
Thank you. At this time, people will move to admit people's proposed exhibit number 11.
No objections, Judge.
It'll be admitted. Okay, and on that date, did you know who that person was or what their connection was to this scene?
No, we arrived on scene and there were multiple individuals that were detained, and we were advised to take photographs of those individuals. We weren't given any other information other than that.
Okay, and do you see that person in the courtroom today that is depicted in people's exhibit number 11?
Yes,
Can you tell me where that person is in the courtroom and what that person is wearing?
I believe he's there wearing green.
Let the record reflect that the witness has identified defendant Marty Smith. So reflect. Thank you. And sir, did you collect any of the evidence, or was your job limited to photographing the evidence?
My job was limited to photographing and assisting with the uncovering of evidence.
Okay, and did you also locate and take photographs of any items, in particular a weapon?
Yes, I did.
Where was that found?
That was found in,
I don't know
Or
if you can.
I'll reword it. I understand why you're objecting. Where did you take that weapon that you took a photograph? Where did you take that picture of that photo? Where did you take that?
I took a photo of that firearm in like an attic crawl space area on the second floor of the residence.
And did you recover that firearm?
I did not recover it, my partner.
All right, and what is the name of your partner?
Corporal Raymond Diaz.
Okay, did your partner also recover the items that were labeled on the placards that are photographed in people's 5 to 10?
Yes, he did.
Okay, and those are the spent casings?
Correct. The spent casings, the bullet, and the firearm.
And would you have also been the individual who would have taken photographs of any mail at the location?
Yes, I did.
People have no further questions for this witness, Your Honor.
So you witnessed your partner recovering all of those items, are you standing right there when he does it?
Yeah, I am standing with him when he recovers those, so I can document if there's anything else that gets uncovered in the process that needs to be taken photos of.
And how many shell casing photos did you take?
I don't have the number of how many.
You have a,
Oh,
you have a in your hand?
if this is all of them, then. It's like 5 photos of the casings and 1 of the
Five cases and one bullet.
Well, there's 4 casings, there are 5 photographs just overall. I guess, are you asking me?
Are they numbered?
They're numbered 1 through 4, those are the casings, number 5 is the bullet. My apologies, I thought you were asking how many actual photos I took.
Some prosecutor, you said you had 5 to 10.
That's photographs, right?
So, and for evidence, 5 to 10 are the 5 photographs that Attorney Polk is referring to, but 1 through 4 is the 535th photograph. Exhibit 10 is the actual bullet.
Exhibit 10 should be the actual.
That's correct. Okay, so 10 is the bullet.
And 5 through 9 are placards 1, 2, 3, and 4.
I'm having a problem. How many spent shell casings were recovered?
There were 4 shell casings recovered, and those
Okay.
were on the scene as placards 1 through 4.
Okay, and then, so number 5, 6, 7, and 8 are shell casings, correct?
I believe they were referring to the photo, the numbers on these specific photos.
Would it help if you show the photo?
Sure.
Yeah, I-
Yeah.
What I'm trying to understand is, they're saying 5, but you only have 4 shell cases at the front, so.
So they labeled this picture as number 5,
It's equals 5.
Okay.
but that is a picture of placard 1, which is a casing.
All right.
And then 6 is placard 2, which is another casing.
Okay.
Seven is a mid-range photo of the 9mm casings in number 2 and number 3. And then 8 is a overview photo of all 4 of the casings south of the front porch. And then 9 is a mid-range photo of the fired bullet, which is placard 5. And then 10 is a closer up image of that same bullet.
Thank you for that clarification.
I don't have any additional questions, but that's good.
I introduced 2 different people. At this time, the people would like to call Raymond Diaz, who is stand.
Mr. Yellow says she's on her way.
Oh, thank you. Mr. Ray, is that on the record? No. Okay, thank you. Swear to tell the truth, whole truth, and nothing but the
I do.
truth. Okay, have a seat and make sure you speak up in the microphone.
All right, good morning, Mr. Diaz. Can you please state your name for the record?
My name is Raymond Diaz.
Thank you, sir. And do you have a title? that we should use?
Detroit Police Court.
Okay, we'll be at it. And how are you employed here? You said Detroit Police?
Correct.
And were you working in your capacity as Detroit Police on May 31st, 2022?
Yes.
And were you working evidence on that date?
Yes, I was.
All right. And were you called to a location at 19431 Edinburgh in the city of Detroit, County, Wayne on that day?
I responded to that location the following morning. I worked midnight shift, so I received the run at 1:05 on the following, on June 1st.
Okay, so would it have been like the early morning hours then?
Correct.
Okay. And when you arrived on the scene, did you see officers there?
Yes.
All right, was the location surrounded at that point?
Yes.
All right, and was a search being conducted at the location when you arrived?
They were finishing up on the search when I arrived.
All right, and when you arrived, what was your role that day?
I arrived, I received preliminary information of what had occurred or what they knew up at that point. I was directed to photograph 5 individuals that were being detained. My partner photographed the individuals I received, I got their names and what they were wearing. Once that was completed, then we proceeded to the residence.
Okay, and when you proceeded to the residence, did you proceed with working with anyone?
With my partner, Trevor Callahan.
All right, and would it be fair to say that his job was to photograph the items while you document the items?
That's correct.
All right, and did you locate items that you were documenting that day?
Yes.
Can you tell me what you located at that Edinburgh address?
As I approached the residence, still south of the residence, I found a fire bullet on the street in front of the location of 19401 Edinburgh.
Okay.
I marked that with a placard 5.
Okay.
At the residence, just south of the porch, on a gravel or a rock garden, white rocks, I notated 4 fire casings. And I marked them 1, 2, 3, and 4. Went inside of the residence, did a walkthrough on the side door along the north side of the residence. There's a gun holster on the floor, marked that with number 6. And on the second floor loft bedroom on the west crawl space, I recovered a firearm.
Okay, and I'm going to approach you, sir, with the people's entered exhibits 2, 5, 8, 10, and 9. Do these photographs accurately represent the items that you located at that Edinburgh address?
Yes.
And did you place those items then into evidence?
I did.
Okay, how do you do that, sir?
Once the item is marked with a placard, and my partner photographs that I notated, I proceed to collect each individual piece, just placed in if they're small, like in this case, in a coin envelope, a small envelope.
Okay.
The envelope gets labeled with the number of placard of what it corresponds to. I write on the envelope below the number, what the item that I placed inside of the coin envelope is, and that small coin envelope gets placed in a larger envelope that gets notated with the report number, the date, the location, what the item is, my name and whoever I'm working with, goes on the envelope. The envelope gets sealed, and then a evidence tag is attached to that particular item.
Okay, and would an agency number also be placed on those pieces of evidence to demark what case they belong to?
Correct, that's the report.
All right, do you have the report number for this case?
Yes, I do.
Do you need to refresh your recollection by looking at your report, sir?
Yes.
Do you have a copy of your report?
Yes, I do.
Please do, sir.
It's 2205310420.
Thank you.
That's the report number, and each item of evidence or everything that follows with that report as that same.
Thank you. I am now going to approach the witness with people's proposed exhibit 12, Your Honor. I'm handing you a document, sir. Can you please identify what that document is?
This is the Department of Michigan State Police Forensic Science Division Firearms Laboratory Report.
All right. And at this time, people would move to admit pursuant to MCL 76611B that MSP report, Your Honor. If I may, I will, for specificity, I will specify further. Okay, I'm sorry. Any objection?
Well, Judge, he had this witness identified. I mean, he's not making any assertions in reference to this report.
I can't hear. Sorry.
You say the objection again for the court.
That this witness identified this report. He's not making any assertions in reference to this report or its contents, is he?
That's the question for the prosecutor. I don't believe, are you?
I'm not, we're not going to have him make any assertions as to the report. I'm just going to have him identify items on the report. But my motion to enter this report is independent of any testimony of this witness pursuant to MCL 7611B.
Officer, sorry for Corporal Diaz, can't speak to MSP's report.
No, he cannot.
So stipulation would be more appropriate.
Well, the people don't have to actually get a stipulation from defense counsel. The report can be entered under MCL 76611B, Your Honor.
And if that is the case, then Judge, I just object and let the court make the determination as to whether or not the report comes in pursuant to that court rule.
So I'll read the statute and then, so MCL 766.11B states that the rules of evidence apply at the preliminary examination, except that the following are not excluded by the rule against hearsay and shall be admissible at the preliminary examination without requiring the testimony of the author of the report, keeper of the records, or any additional foundation or authentication. A report of the results of properly performed drug analysis field testing to establish that the substance tested is controlled substance. Not relevant here. B is not relevant. C, a report other than a law enforcement report that is made or kept in the ordinary course of business. I'm assuming that's what you're referring to, section C. Correct. Okay. So with that, the statute says that you don't have to, lay a foundation or any additional authentication. But my point is, Officer Diaz can't speak to the report that is allowed to be admitted if he didn't provide it or work for the department that prepared it.
Very well, Your Honor. But my motion to admit was separate from any questions of Officer Diaz, but I do respect your objection to my asking Officer Diaz as anything about that report.
Okay.
So I would ask that it be admitted independent of any questioning of Officer Diaz.
Okay, I will admit it.
Thank you. At this time, I actually have no further questions for Officer Diaz.
I don't have any questions.
Okay.
Yes. At this time now, Your Honor, I'd like to call Antonio McGowan. Okay. Yes, Your Honor. I was going to actually read it into the record as part of my making a find over, but I will approach. Thank you. Thank you.
Good afternoon. Where you at, okay? You swear to tell the truth, the whole truth, and nothing but the truth. Okay, so have a seat and make sure you speak up in the microphone, okay? Good afternoon, Mr. McGowan. Can you please state your name for the record? Thank you, sir. I'm going to take you back to May 31st, 2022. Were you at an Edinburgh address at 19431 Edinburgh in the city of Detroit County, Wayne?
I don't know that.
All right. Were you, do you know someone by the name of Teese? Do you see that person in the courtroom today? Can you please identify where that person is in the courtroom today?
Green shirt.
Let the record reflect that the witness has identified Martise Smith. Someone reflected. On that day, May 31st, 2022, did you observe the defendant with a gun? And was that a handgun? Did you observe him shoot that handgun?
I saw him raise it up in the air.
Okay.
I was behind him.
I'm going to ask you to speak a little bit louder, sir, so that we can all hear you.
I said I was behind him.
All right.
And I just saw him raise it in the
All right. And were you at a house on that Edinburgh address?
air. Yes.
And was that the house belonging to Teese?
Yes.
Okay. And did you see what he did with that gun?
No.
All right. Did you have an opportunity to speak with the police on June 1st, 2022, sir?
I'm not sure what the date was.
All right. May I approach the witness? I'm going to approach the, let me lay a foundation, Your Honor. Do you remember speaking to an officer about a shooting on that May 31st date?
Yes.
All right. And do you remember answering questions?
Yes.
All right. And do you remember answering those questions posed to you by a Detroit police officer?
Yes.
All right. And may I approach the witness, Your Honor? Yeah. Mr. McGowan, I'm handing you a document. Can you please identify what that document is I've just handed you? All right. And is your, sorry, would you say that was Sergeant Crenshaw asked you? All right. And did you sign the bottom of that statement form? That's your signature, sir? All right. And are there 2 pages to the statement, sir?
Yes.
And did you sign the bottom of that, the second page also? All right. And when you signed the bottom of that page, were you acknowledging that everything you told Sergeant Crenshaw was the truth, sir? All right. And on that day, would it be fair to say you had a good memory of what happened just, shortly before? Okay. All right. And when you were asked, do you recall someone shooting from the porch at a vehicle? Do you recall answering yes? Okay. And when you were asked who was shooting, do you recall answering it was Teese? All right. And when you were asked what was he wearing, did you answer wearing a white t-shirt and beige shorts?
I can't remember exactly what color it was at the time.
Okay,
at
but
this point, but then if it says on there, that's what I said.
Okay.
That's what it is.
Thank you. And when you were asked how many shots were fired, do you recall saying I heard 2?
Yeah.
And do you remember being answered what happened? And you stated, we were sitting on the porch. I was talking to a young lady. While talking, I heard a gunshot.
Judge, I want to object to her reading reading the statement. She can ask a question and whether or not he said it, but she doesn't get to read the statement to the record.
Very well, I'll condense it. Do you remember answering, I observed Tease holding a gun in his hand pointed at a Nova in the street?
When I looked up, I saw his arm hanging on towards
Okay, so with what?
the vehicle.
Okay. Thank you. I have nothing further.
You gave the statement, you were under arrest at that point? You gave the statement?
Yeah, yes. Handcuffed.
Okay, and so,
Yes,
so you were, provided Miranda's, is that correct?
yeah.
They gave you a Miranda? You signed that statement? Okay, and were you, told that you were a suspect?
I don't remember that. I don't remember the terminology, maybe. I'm not sure.
Okay, so what were you told by the officer in reference to?
I was told that,
Objection, hearsay.
I'll work it out.
Okay.
Okay. At any point in time, did you feel that you were a suspect in reference to this?
yes.
Okay, and what made you feel that you were being, identified as a suspect?
Because, I was detained.
Okay, you were detained. Were you still on Edinburgh when this statement was made?
No,
Okay, so where were you?
we were downtown, one of the, streets.
How did you get downtown?
I was transported.
Okay, so you were transported by the police to a location downtown?
Yes.
And then you were, questioned in reference to if you knew anything about this situation?
Yes.
You never told the police you saw, Mr. Smith shooting, did you?
At that point, I had.
Okay. So you never, that's not a part of your statement, that you saw him shoot that weapon?
I wasn't, they didn't ask me that until I got downtown.
Okay.
So during my transport, there was no conversation about that.
Now, approach with the judge.
Yeah.
I just want you to take the opportunity, to look at your statement and see if you can identify where you say you saw Mr. Smith discharge that weapon.
And Your Honor, at this time, I'm actually going to object because it's a mischaracterization of the evidence. The people asked the witness about the questions that the officer asked him. One of those questions was, who was shooting? And the answer was, it was Tease. And that was acknowledged by the witness on the stand. So I would object to this line of questioning as it's a misrepresentation of what actually was already placed on the record as testimony.
Absolutely is not, Judge. I'm asking him a different question as to whether or not he saw my client discharge that weapon. And in conjunction with that, is that in his statement?
Okay, discharging and shooting the weapon.
That's not the issue, because I'm asking him if he witnessed it. He says something in his statement, but my question is, do you just say something versus you actually observe something?
Okay, so testimony was given that Mr. McGowan responded when reviewing his report or his statement that he saw Tease shot. I will allow you, Attorney Pope, to let Mr. McGowan review the statement to answer your question whether or not you put that in the statement. That's what you're asking, right?
I am.
Okay, so Mr. McGowan, you can review your statement quietly and answer yes or no.
So in reviewing your statement,
Yeah.
did you tell the police you saw Mr.
That's what the
Smith
statement said.
discharge that weapon?
Yeah.
May I approach the witness there? I want you to look on page 2. Read that paragraph. Okay. So in looking at what you told the police, did you witness Mr. Smith discharge that weapon?
Like I said, I was standing behind him. So he had his arm pointed with the firearm.
Like if the
I
record,
can't-
let the
I
record
can't-
reflect that the witness reached out his arm.
You can't see a
Mr.
bullet.
McGowan, only one person can talk at a time. I know you're trying to answer the question, but certain things have to be put on the record, just so they can be in writing, just in case it has to be reviewed, okay? So reflective. You can continue to figure out.
Yeah, so I looked up, firearm pointed, he started at the note.
That's your testimony today, but that's not what you put in your statement. correct?
That's the same thing on the piece of paper.
You did not say that you saw him discharge the
Objection,
weapon.
argumentative.
You did not say in your statement that you saw him discharge the weapon. did
What
you?
is that?
Well, you read it, sir, doesn't?
I mean, tell me your interpretation.
Mr. McGowan didn't answer yes, and he said he didn't speak.
That's fine. George. I don't have any additional questions to this witness, Judge.
No further questions for this witness. Thank you. Okay. Your Honor, may I recall Sergeant Delaney Jones for one brief question?
Unknown. Be open and direct,
I haven't closed my direct.
to Jones. Not crossed.
Cross, Mr. Jones, on any questions she has. No, not at all. And before we get it, Mr. Jones, can I just go with you in the hallway while you've been waiting out there about the case?
Thank you. Sergeant Jones, I'm going to take you back to that May 31st date at the Edinburgh address. When you were when you were inside the undercover vehicle, in that vehicle that you were driving, what make of that vehicle was that vehicle?
It was a Ford, Fusion,
Was it Ford Fusion?
gray color.
What was the last one you said?
Gray
Gray
in color.
color.
Yes, Your Honor.
May I have a moment, Your Honor? Yes. Were there other cars parked in front of that location, the Edinburgh location when you were there? Yes,
It was
in your undercover vehicle.
I never made it to the front of the location.
Okay.
Correct.
Were there other vehicles parked in the area that were of the shooting when the shooting occurred?
Yes,
Okay, all right. And were there individuals in those other vehicles?
I can't recall.
Okay, all right, thank you, nothing further.
Any cross based off of those?
No, whatsoever.
Okay. All right, sit down again. Other witnesses?
No, Your Honor, no other witnesses. I do want to read into the record the in relevant portion, People's Exhibit number 12. That being the laboratory analysis by the Department of State Police Forensic Science Division, laboratory number MD 22-1571, agency number 2205310420. Record number 1, date received June 2nd, 2022, date completed June 24th, 2022. This would have been a laboratory analysis conducted by forensic scientist Shelby Sismoniak. That would be Shelby SHGLBY. Last name SZYMONIAK, which would indicate that evidence from MD 221570, container 1, tape sealed envelope DPD item 4 containing 9mm Luger caliber Hornady fired cartridge case. Evidence received from MD 221571, container tape sealed envelope DPD item 1 containing tape sealed envelope containing 1A, B, 1A, 1A, 1B, 1C, 1D. This would list 4 9mm Luger caliber cartridge cases, fired cartridge cases. Container 2, tape sealed envelope DPD item 4 containing 2A 9mm Luger caliber Taurus model G2C semi-automatic pistol, serial number TLP 21473. Item 2B, box magazine containing 8 to 9 Luger caliber cartridges, unsealed envelope containing 1 9mm Luger caliber cartridge. Container 3, tape seal envelope DPD item 2 containing 1 fired bullet. Evidence generated during examination, MD 221571, container TF2A, heat sealed bag containing test shot envelope containing test shots from item 2A. The results of the physical microscopic examination indicates that 1A through 1D, that would be MD 221571 fired cartridge case and 1 MD 221570 fired cartridge case are identified as having been fired in item 2A. Item 3 was listed as inconclusive as having been fired from 2A. Item 3 is not suitable for comparison. Item 3 is consistent with being a 38 9mm caliber class fired metal jacket bullet displaying conventional rifling specifications of 6 lands and grooves with a right twist. I will also read conclusion scale for microscopic comparison. It states the following descriptions are meant to provide context to the levels of opinions reached in this report. Identification. This is the strongest statement of association that can be expressed. An identification is made to a degree of practical certainty when there is an agreement of all discernible class characteristics and sufficient agreement on the individual characteristics and tool marks. When sufficient agreement exists in part, this means the likelihood of another tool producing the same marks is so remote is considered practical impossibility. Elimination. This is the strongest statement of non-association that can be expressed, and elimination is made when it is physically impossible for the items to have been marked by the same tool, fire, or same firearm. Your Honor, at this time, people have read in the relevant portions. We do want the court to draw their attention to what has already been read as items 1A through D, having been identified as fired from 2A. So for the purpose of bind over, we do ask the court to draw their attention to that item in People's 12. And at this time, the people would move to bind over if the defense counsel is not presenting any witnesses.
We are not presenting any witnesses at this preliminary exam, Judge. She's made her motion to bind over. We believe that people haven't demonstrated that there was any specific intent as it relates to assault with intent to commit murder.
Your Honor, I'm sorry, Attorney Cole, I can hear you, but the court reporter can't.
You need to step in front of the mic, please. Thank you. I appreciate it. Start over.
Okay, so the people have made their motion in reference to the charges. We believe that they have not demonstrated any specific intent whatsoever as it relates to an intent to commit murder. With that, our position is that those charges, the assault with intent to commit murder, as well as the felony firearm corresponding with that, not be bound over.
Your Honor, at this time, the people request to bind over on all charges. We have testimony from Mr. McGowan, who identified the defendant in this courtroom, and the defendant being the person who pointed his gun, pointed in front of him, and shot at into a car. Yes, there is inconsistency as to the make or model of the vehicle, but I would argue that that is a non-issue. If it is even an issue, it would be a matter of transfer to intent. However, I would argue that it is in fact the same vehicle. There is, and we have the testimony of the witness indicating that he heard 2 shots. And that would be Wantonia McGowan. We have the testimony of Sergeant Jelani Jones that he heard 4 to 5 shots, one of which took effect on his vehicle. This coincides, the shooting coincides between the same as strike that. We would argue that there is continuity in testimony when you hear that there is multiple shots fired by Sergeant Jelani Jones as well as by Mr. McGowan. You have the testimony that this defendant by Mr. McGowan did raise his arm and point it at the vehicle. His actions and intent are displayed by the deliberate nature of raising his arm and pointing and firing multiple shots. One does not fire multiple shots, but for to kill, harm, or do assault with an intent to do great bodily harm, as well as assault with intent to murder. So I would ask that all those 2 counts, as well as the felonious assault and the corresponding felony firearms that follow the first 3 counts of assault with intent to murder, assault with intent to do great bodily harm, as well as assault with a dangerous weapon to coincide and follow through.
Okay. So the court heard testimony from 3 witnesses, Sergeant Jelani Jones, who's also the complaining witness on this case, also from 4 witnesses. Evidence Tech Trevor Callahan, Corporal Raymond Diaz, as well as Wantonia McGowan. To save everyone time, I don't need to read the facts, we all heard this today. The issue here is intent. So we have that we saw Mr. Smith raise the gun and discharge it, although there was some inconsistency about whether he discharged it, but he stated in testimony today that he did, and that he was on the porch, he was standing behind Mr. Smith. So the question is not whether Mr. Smith fired or discharged the firearm today. The question is what his intent was. So the argument for the people is that this could be transferred to intent. The problem is that there was no one in any other vehicle for Mr. Jones' testimony as well as Mr. McGowan's testimony. So the original intent, I'm not sure what it was based off of what I have today to look for. people argue that anytime someone raises a gun and fires shots, that it's to kill versus harm someone. I would say that's true if you were aiming at a human being or something living to harm. But the original reason why Mr. Smith was firing a handgun is not clear to me based off the testimony. It could have been very well that he was shooting at Mr. Jones' vehicle, but the testimony, we have two different cars, a Chevy Nova or Nova, with testimony from Mr. McGowan, and a Ford Focus was what Officer Jelani stated, Jones stated that he was driving. So I do not think that the people have met this burden, even at the probable cause standard, to show that there was an intent to kill, when the original intent is not clear here, because we don't know what he was shooting at. There's no testimony. Mr. McGowan did not say, it could not say, or would not say, I don't know what it is, what he was aiming at, who was in the car, that there was no one around, and he didn't see anyone in the vehicle. And even Sergeant Jones said that he didn't see anyone in any other vehicle. So with that, I am not going to bind Mr. Smith over on count 1, with the assault intent to murder, or count 2. And the felony firearms attached to those both counts. So we'll just be on felonious assault as well as felony firearms attached to felonious assault. And Mr. Smith, your arraignment on the information will be February 16th at 9 o'clock across the street at Frank Murphy Hall of Justice.
Thank you very much, Bill. When you staff have a group and. Getting out the way, so. Hardly giving you the look. Give it back. It wasn't so much.
If the judge needs a break or not. I'm here all day. Take a break though.
It's a whole, right, Attorney Dion?
Yeah, I just want witness, right?
Yeah, I'm gonna try to make it quick, Your Honor, so that you guys can get out of here.
If you have to get up here,
I'm good.
okay, so it's not.
As long as staff is good, I'm good. We're not moving. I'll try to get straight to the point.
I did, okay. So what you gonna do?
No.
All right, I'm going, I gotta go.
Goodbye.
Want me to give the?
Yeah, I'll take it. Whatever it is, I'll take it.
Okay.
Take, oh, I can propose now. I'll deal with it.
Judge, can we file that release of the subpoena?
Oh, yeah, yeah.
Oh.
Is there a copy of it? Yes.
Where do you want him? Do you want him to stay with you?
I don't know. That's gonna be interesting. Because he's not gonna be able to hear, so.
Cynthia, I have no objection to him sitting next to you.
Can you, he's not, can you hear? You can't hear, right?
Is this straight?
Can you bring it back to?
Anybody else, speak loud. Everybody got to speak loud.
I have a right.
Okay, I'm just speaking, I'm gonna speak in the microphone. So I guess we're all, yeah, I'm gonna move myself. Let me move myself.
She's saying like she's trying to get him some.
Oh, her? Yeah. So who is it out there, little girl? I tried to get her.
No, but she told him don't agree to let him understand and she wanna talk to you.
She don't need to, okay, I'll be right there. I'm gonna take pictures. Okay.
Yeah, this part. I'll go see if the officer need to sign out.
Yes, ma'am.
We no longer have to. Copy it, right?
Okay. All right. And the original, I'm keeping in the file, we can still, court still on it. And it's for- I haven't finalized.
So we're gonna talk up, okay? Can you hear me when I talk up like this? Can you hear, or you need the mask down?
Which ear is he? Have hard hearing? Which
You
ear is
only have
that?
like 33% or something. Which ear is it that you can't, that you have some hearing in? The right one is the one you have some hearing in?
And then this one, no here.
He doesn't have time. Switch. Yes, ma'am. You're right. Sit here for me, okay? Thank you. Oh, no. We warriors, I don't know. I don't know.
It's not done, but we will put.
You hear me?
I know you wanna do a lot of color. No, I still have some thoughts on here. It's like a real pressure.
Huh? You like, let me put all this back here. You just got messing with me. There. I mean, oh, my purse. It's amazing. It's amazing. Oh, wait. Yes, sir.
I'm talking to the defendant. Needs me to raise my voice, just, get my attention. I'll raise my- I usually talk pretty loud. The mic, it's interesting, I said that.
Everything over there here is much better over the other. I was over there, I was like, gosh, I gotta stand over there when we do. Yeah, over there you can hear everything. I had to do that in Judge Jefferson's courtroom. They actually brought a speaker right here for me because they know I'm a little. Your right ear is your bad ear.
So when we get time.
So if he tells you that he can't hear, I will speak up.
Do you want me to pull my mask down?
I'm okay with it if everyone.
I'll just, oh. yeah.
Mr. Williams, Mr. Williams, can you hear me at this level? Okay, can you hear me now?
Say yes.
Yeah.
If you can't hear me or anyone, raise your hand. Okay, just like that. If you can't hear something, raise your hand and we will repeat it. And if you need it again, raise your hand, okay?
That sounds like a plan, because I'll see you raise your hand as well. All right.
Okay. Okay.
Okay.
Take it to the head.
Is this
for us? That's for, Ms. Diallo to give it to the court.
Oh, I got,
You got it already.
yeah, a bunch of them. Oh, they gave me a-
You got the file.
How many more?
Oh, yeah, that's, thank you.
You got a bunch of them. Okay. Okay, we are on the records as the people of the state of Michigan versus Joseph Jermaine Williams. Case number 2260118. Mr. Williams is charged with 1 count of weapon carrying concealed. Today is the date set for a preliminary examination. Appearances?
Good morning, Your Honor. Daniela Parrish on behalf of the people, P85495.
Good afternoon, Lillian Diallo, on behalf of Joseph Williams, who's present to my left. Say your name.
Justin Williams.
Thank you.
And just for the record, Mr. Williams is hard of hearing, so we will all be speaking very loudly. And Mr. Williams, as I stated off the record, if you need us to speak up, just raise your right hand and we will speak up and repeat what we said. You understand that? Okay. Any preliminary matters?
No preliminary matters from the people, Your Honor.
Just a sequestration order. I'm sorry, sit down. Sit down. A sequestration, but there's only one witness, so.
Okay, and the one person in the courtroom that's not staff or part of, either parties here, can you state your name?
James O'Shea, I'm the officer in charge of the case.
Okay, any objection?
No.
Okay, you can call your first witness, Ms. Parrish.
Thank you, Your Honor. And the people call Paul Sweppy.
Your Honor, I apologize. Can I have just a moment to clarify a date prior to us going on the record?
With
So that I
Officer
don't-
Sweppy?
Yeah, is that, would you mind?
No, what day?
Just notice, I apologize. My apologies.
He's not sworn in yet, so.
Okay,
Go ahead.
Ryan, nice to meet you.
That's what date.
Yeah. Yeah.
Thank you, Your Honor, my apologies.
Okay, no problem.
Thank you.
Yes.
Okay. You swear to tell the truth, go through the record.
Yes.
Now we have. Make sure you speak up very loud with the microphone.
Absolutely.
Okay, whenever you're ready, Ms. Parrish.
Thank you, Your Honor. Officer Sweppy, I have my mask down a little bit. Court, we've already discussed this. If you need to pull yours down a little bit because the defendant is hard of hearing, so we want to make sure we get everything that he can also hear. All right? Thank you. Officer, please restate your name for the record.
Officer Paul Sweppy,
Who are you currently employed with, officer?
the Detroit Police Department.
In what capacity?
I'm a police officer at the 9th precinct.
How long have you been a police officer, sir?
Since October of 2017.
Were you employed as a Detroit police officer on October 14th, 2022?
Yes,
Were you by yourself or with a partner on that day, sir?
I would have been with 2 partners.
Do you recall the names of your partners, please?
Yes, Officer Baldwin and Officer Holmes.
Were you in a full or modified uniform on that day, sir?
I would have been in a Class C uniform, which is what I'm wearing right now.
Could you describe that for the record?
Green pants with a dark colored coat and a outer carrier.
Police indicated on that uniform?
It is.
Were you on foot or in a scout car on that day, sir?
We were in a scout car.
Were you driving or were you passenger?
I was driving.
Did your duties as police officer take you at or near 18300 Morant Street in the city of Detroit, County of Wayne?
Yes,
What's at this location, officer?
it's a gas station.
Can you tell us why you were at or near this gas station on that day?
We generally give special attention.
I'm sorry, I'm gonna object as to what we do and, okay.
If you could just answer the questions as yourself, please. Why were you at this location on that day?
So I try to give special attention to gas stations and liquor stores because that's generally where most of the crime occurs in the city.
Were you patrolling or were you at the actual gas station?
Patrolling.
Once you arrived at this gas station, did you observe something that drew your attention?
Yes, I observed a individual inside pull a firearm out of his pants.
Okay. Would you be able to recognize this individual if you saw them again today, sir?
Yes.
Is that person in the courtroom today?
Yes.
If you could please tell us where that person is in the courtroom and the article of clothing that they're wearing.
He's wearing a green top, black pants.
And his location?
He's right next to you to your right.
Thank you. Your Honor, may the record reflect the identification of the defendant, Joseph Williams, please? So reflected. Thank you, Your Honor. So, officer, how you indicated what you observed. How far were you when you observed the defendant?
I'd say roughly 15 feet.
Okay. Was it daylight or dark outside?
The parking lot was dark. The store was very illuminated.
And was the individual inside or outside the store?
The individual was initially outside and then he was inside of the store.
At what point or where was he when you indicated that you observed him? I don't want to misquote you, but could you repeat what you observed and where exactly he was when you observed him?
So I initially observed him at the front of the store. He was standing at the very front of the store by the cash register, and that's where I started to take a look at him.
At what point did you make further observations that you indicated in your that drew your attention, that you indicated initially in your answer?
Yeah, so he was at the front of the store. He appeared to take notice of our vehicle.
objection, speculation, but that's okay. Speculation, objection.
He took notice of our vehicle.
Okay.
Okay, so I'm just sustained, you
Thank
know,
you.
but you can only testify to what you observe someone doing, not what you think someone else was observing.
What observation or what? Yeah, rephrase that. So while observing him, could you please detail what movements or what he did that drew your attention?
He looked at our car and then walked down the first aisle, which is visible through the glass of the store completely, and drew a pistol out of his front waistband.
And you actually were able to observe him pull this pistol out?
Yes.
Were you able to see this pistol prior to him pulling it out?
No.
As a result of these observations, what, if anything, did you do?
I entered the store and asked him if he had a CPO.
Okay. How did he respond to you, sir?
He said no, he was open carrying.
When you entered the store and asked him this question and received the answer, could you describe to us what, if any, other observations you made physically?
Yes, it was inside of an inside the waistband holster that was now on the outside of his pants.
You're referencing to the weapon you had observed earlier?
Correct.
Okay, so, can you say that again?
Yes, the pistol, the handgun was in an inside the waistband holster designed to go inside the pants.
Thank you.
And it was now placed on the outside of the pants.
Thank you. Was this holster and weapon in that location when you initially observed the defendant?
No.
Based on the defendant's admission to not having CPL, what if anything did you do?
We detained him further, pending further investigation into whether or not he truly had one, which we verified through lien that he did not.
Did you recover the weapon, sir?
Yes,
Do you recall what type of weapon the suspect was carrying?
it was a Glock handgun.
Was this Glock handgun loaded?
Yes.
In the course of your investigation, did you verify, as you started to say, whether or not the defendant had a valid CPL?
Yeah, we verified through lien that he did not have a valid CPL.
Did you happen to learn in the course of your investigation if the weapon was registered?
It was ran through lien.
Okay, was the weapon registered?
I believe it was. I believe it was registered to Mr. Williams.
Did you ultimately arrest the defendant, sir?
Yes.
What, if anything, did you do after the arrest?
We, after he was transported to the DDC, we placed the pistol and holster on evidence.
Do you recall the evidence tag number that you placed the weapon under?
The pistol was placed on the first evidence tag on that LCA, which is the report number. The holster was placed on the second.
If I showed you your police report, would that refresh your memory as to the tag number?
Yes.
May I approach?
So it's a pretty long tag number.
Your Honor, would, if there's no objections from defense, may you read that number off?
I'll stipulate that
Okay.
he recovered a handgun.
Thank you.
That
That
is
is
registered.
There's an evidence tag number. Okay,
Whatever it is.
thank you.
Thank you.
Your Honor, based on that stipulation, I'd just like to read into the record that the evidence tag number was 221-014-0012-2. No further questions at this time, Your Honor.
Thank you. I'm sorry, officer, no, you sit down. I got this. I'm sorry, what was your name again? I do apologize. Which one?
Paul Sweppy?
Oh, I thought you were Sweppy. No, ma'am, I'm Shay. Oh, Shay. Oh, no wonder I was messed up. Okay, so Officer Sweppy, I'm gonna ask you some questions, okay? If I ask you a question and you don't understand, just let me know and I'll do my best to clear it up, okay? Okay. Were you like that special ops or ceasefire or any of that stuff right there?
Yes.
Okay, so your whole goal is to just go around and see if people that you don't know have handguns or reduce crime, whatever it is, right? Specialized unit, let me clear it up.
You said a lot of things,
I
right?
know, a specialized unit, right?
Proactive directed patrol is generally what I'm tasked with.
Good job. Okay, and so you are special ops, because it was 3 of you in the car, correct?
Yes.
And you are governed by the practices, policies, and procedures of the Detroit Police Department, correct?
Yes.
Now, you had no idea who the person was that you said you saw with a gun, right?
Yes.
So you didn't know this young man before you said you saw him with a gun, right?
I don't believe I had any previous contact vocally with him.
Okay, but you didn't know him to be a felon, did you?
No,
All right, and are you aware that the gun was registered to this young man, right?
not at the time.
Okay, but you went up and asked him for a CPL, is that fair to say?
Yes,
And he hadn't done anything wrong, other than you thought you saw a gun, right?
no, he had a pistol concealed on his person.
Okay, are you aware that you can do that? And you can have a pistol on your person in public or in your home, as long as you're not doing anything wrong?
You have to have a concealed pistol license to carry a concealed pistol on your person.
Apparently you don't know what Clarence Thomas said, but we'll argue that later. All right, so that's the only thing that drew your attention to this person right here is a weapon, and that's it, right?
Yes,
And you went and you know he's a citizen of the state of Michigan, right? Right?
yes,
All right, and you went and engaged the citizen and said you stopped him, did you not?
I asked him if he had a CPO.
Okay, so right, so you stopped the person and asked them, did you have a concealed pistol license, correct?
I initially made contact with him and asked him if he had a CPO.
Okay, so were you speaking loud or what?
He heard me.
How?
He responded to me.
So let me ask you something. There's body cam, correct?
Yes,
Where is that?
I'm not the person who'd be charged with producing the body cam.
Okay, but your body cam was clearly active, correct?
Sure.
Dash cam clearly active, right?
Yes,
Per practice, policy, and procedure, correct?
yes,
All right, and so, is there, and your body cam was uploaded immediately, would it not have been? To the cloud or wherever?
I don't know what the timetables are. I don't deal with it.
Okay, but you do know this, the officer in charge is in the courtroom, correct?
Yes,
All right, and are you aware, yes or no, that one of the practices, policies, and procedures of the Detroit Police Department is to give the OIC laptops so that they can immediately have these cams downloaded or uploaded to their cloud?
I'm not aware that the laptop's supposed to be given to people per policy. I have no knowledge of that.
Oh, that's fine, you're not an officer in charge though, right?
No,
All right, okay, and all right, I'm gonna sit down now and I'll just argue later. I'm gonna sit down now. Thank you. I don't have any other questions for you. Sweepy? What is it? Sweepy, okay, Sweepy, thank you.
Raise your right. No further questions.
Yes.
Okay, Officer Slippy, you put that down. Thank you.
Were you able to hear me? Thank you.
I think everybody. No further witnesses from the people, Your Honor. Okay, are you? Thank you. People move that Joseph Jermaine Williams be bound over on count 1, weapons carrying concealed, and reserve argument.
Okay, may I judge?
Yes.
So pursuant to New York Pistol Association versus Bruin, it is a site of 597 US. It's a 2022 case. We don't have the page because it is so new, right? Pursuant to that case, and it was not, I believe, to help someone like Mr. Williams, but you are now allowed to have a weapon inside and outside of your home for self-defense. Police officers, until they do something here in Michigan, are not allowed anymore to walk up and specifically ask you, do you have a CPL? What Bruin did, and Bruin is B-R-U-E-N. I didn't want to send you paper.
I have it right here.
Oh, okay. What Bruin did was, it helped the gun lobby, but also it expanded self-defense. So there was a ruling, I think it was the Heller ruling that is spoken about within the Bruin ruling. And I think Heller is H-E-L-L-E-R, and I can go back and get the specific site. Heller spoke to having a weapon for self-defense in the home only. Well, Clarence Thomas, in giving the opinion, which I was quite shocked that he gave, because I haven't heard him say 10 words in 100 years, specifically said that the Second Amendment shall not be infringed, period. So unfortunately, that ruling, it means it's going to be the wild, wild west out here. So they can have guns unless you know that there is something that that person is engaged in. You can no longer walk up to a citizen and ask them, do you have a CPL? As such, Judge, this case should fail because it was a Fourth Amendment violation against this person right here, who's to my right. We do understand pursuant to lien, which came in, which was hearsay, but this is a lawfully registered gun. I have no idea who this young man is, whether he said whatever he said. You cannot ask him for a CPL and then seize his person. So we would ask, Judge, that this matter be dismissed. Thank you.
Do you need some time to pull the case up?
I can send it to you.
Yes, if you could.
I'm making 2 copies.
I can give you the relevant
Is
page.
this a Supreme Court case?
Absolutely.
Okay, because all I heard was New York, but then I heard Clarence.
Oh, it's 135 pages.
Yeah, but the pages that are relevant are going to be pages 8 through 63, that speak specifically to that opinion. I can email it however Your Honor wants, or Madam Prosecutor wants. Which one?
RIC at Wayne County. Your Honor, obviously, the fact that this case that defense has cited in the pages in regards to this ruling is nearly 50 pages, excuse me, more than 50 pages. I would state that being so new and citing that it would be a violation of Fourth Amendment, I would have to say that that would be a question of fact for a trier of fact. But at this point, with the probable cause here at the preliminary exam, in the state of Michigan, our officers indeed are allowed to investigate because we have an open carry law that indicates that you are indeed allowed to open carry. However, as the testimony indicated, the defendant was not open carrying at first. He had a concealed weapon that he pulled out after seeing officers, and then he, at that point in time, opted to make it open carry. However, when our officer observed him, he was carrying this weapon concealed. This was very clearly stated in the testimony. Our officers, after observing the concealed weapon being pulled out, did the right thing by investigating and first asking if he has a CPL. He indicated, he heard him clearly, he indicated that he did not have a CPL and stated that at that time he was open carrying. However, a few minutes before, a few seconds before, he was not. Because he openly admitted he did not have a CPL, officers in this state are allowed to detain him. They did detain him and did confirm via lien that he does not have a CPL. Now, lien is not hearsay. It is not a statement by a person. Lien is a machine that comes under business records. It is not hearsay. So it was verified, and it was verified that the gun was registered to him. So at this time, at the preliminary stage or preliminary examination stage, probable cause has been met. And if there is a change in the law or a feeling that there has been a Fourth Amendment violation, that should go over to a trier fact over at circuit court and be argued there. Thank you, Your Honor.
You want me to put it on the record specifically, Judge?
I just have a question for both parties. It's my understanding the testimony that Mr. Williams stated he was open carrying. He never said, I don't have a CPL.
He said to him, no, I'm open carrying. Because he said, do you have a CPL? And the testimony was no,
And I prefer that they, maybe the court reporter read it back, but to my recollection, it was no, I'm open carry.
But see, Judge, that makes it worse for Madam Prosecutor, because you may not walk up to a citizen. Let me just deal with a Fourth Amendment challenge, and absolutely, this is the absolute place to deal with a challenge. The stop and detention of a citizen is a seizure under the Fourth Amendment. That comes from U.S. versus Walden, 206 F. 3rd 597, specifically at 602 Sixth Circuit here. Also, U.S. United States versus, now spell this, ARVIZU, which is at 534 U.S. 266, 273, a 2002 case. For a seizure, and this is what it was, the officer said it, the prosecutor said it. For a seizure to withstand Fourth Amendment scrutiny, the court must determine whether there was a proper basis for the stop, which is judged by examining whether the law enforcement officials were aware of specific and articulable facts which gave rise to a reasonable suspicion. U.S. versus Hardnett, HARDNETT, 804 F. 2nd, 353, specifically at page 356, Sixth Circuit, 1986 case, and cert was denied at 479 U.S. 1097, 1987. So now we go to what we're here for now. In the District of Columbia versus Heller, and that's HELLER, 554 U.S. 570, and McDonald versus Chicago, 561 U.S. 742. The courts have held that the Second and the 14th Amendments protect an individual right to keep and bear arms for self-defense. Under Heller, when the Second Amendment's plain text covers an individual's conduct, the Constitution of the United States of America presumptively protects that conduct, and to justify a firearm regulation, the government must demonstrate that the regulation is consistent with the nation's historical tradition of firearm regulation. Further, the United States Supreme Court expanded Heller in New York's proper cause requirement, which is comparable to Michigan's requirement to obtain a concealed pistol license. So the proper cause requirement that is referenced in the Bruin case, which is New York State Rifle and Pistol Association, Inc. versus Bruin, BRUEN, 597 U.S. I don't have the specific case. I do apologize. They have not cited those yet, but it's a 2022 case, right? The Bruin case and the proper cause requirement that is spoken about by Clarence Thomas, the requirement for obtaining an unrestricted license to carry a concealed firearm violates the 14th Amendment in that it prevents law-abiding citizens with ordinary self-defense needs from exercising their Second Amendment right to keep and bear arms. As such, Judge, this case fails. It is not a question of fact. It is absolutely a violation of the Fourth Amendment. It was a seizing, it was a taking, and the problem is you don't know if this person that you stopped before you stopped them was law-abiding or not. There must be something else that you add to that, right? Unfortunately, and I don't know if it's unfortunately, it just is, right? This was not meant to, I believe, help people like Mr. Williams. Just like the one-man grand jury that they quashed and said was illegal was not meant to help people like Mr. Williams. He is collateral consequence of doing away with something that helped someone that you wanted to help. So you gotta take the good with the bad. So now everybody can bear arms unless there is an exception that is not recognized here. An officer can no longer come up, seize the person because you seize them when you question them and ask them the specific question. Do you have a concealed pistol license? It is illegal. You can thank Clarence Thomas and the Supreme Court of the United States of America, which is not partisan, I'm sure. Thank you.
First of all, it was not a seizure under Walden. Officers can go up to any citizen if given probable cause to investigate. And observing the defendant pull out a concealed weapon within 15 feet is probable cause to go investigate and find out if in this great state of Michigan, this person has a concealed permit to carry. And in this case, the defendant indicated that he did not. He was not seized. The officer walked up to him and simply investigated and asked. He did not tell him you can't leave. There was nothing, there was no testimony that indicates at any time there was not a seizure here. He investigated based on probable cause after his own observations of seeing the defendant pull out a concealed weapon. Now, as far as I stated before, if the Supreme Court has now changed the laws where they supersede the state laws of Michigan, it has not been brought to my attention. If the court feels that that has happened and the court wants to rule based on this, we will appeal it and we will reissue. Okay, I do not believe that that is to be judged or ruled on in the district court, as I stated before. That should be ruled on at the circuit court, if indeed this is true. Again, this is the first I'm hearing of it, Your Honor. I'm not going to pretend to know of this case, but I believe that nonetheless, based on all of the sightings she has indicated today, that that is still a question of fact for a trier of fact, because at this stage, we have met probable cause, and in this state, until our Congress and legislature changes the law where the defendant and all the rest of us can walk around with concealed weapons, not open carry. We are allowed to open carry. That is not the argument here. We are here for the concealed. That is a state law, and until that state law is repealed or taken off our books, we have met probable cause, and he needs to be bound over. Thank you, Your Honor.
Okay, so I do believe that this is important to deal with this issue. That's the whole point of this court. The question is not what happened after he was stopped by the police. It's whether or not the police had the right to approach Mr. Williams after the DSPL and then proceed to detain him or arrest him. Based off of an answer that I believe was, I'm open carrying. I would like to, because I'm the type of person, as you stated yourself, Ms. Parrish, this is something new brought to my attention. I am not, I might have on a black robe, but I don't know it all. And I am not ashamed to say that I don't know any of the case laws that Attorney Diallo has brought before the court. And I don't think that I can make a decision if it is something new. And it's a 2022 case. I have not been briefed on it, but I want the opportunity to at least read through those cases to make a decision with my due diligence and to give you the opportunity to as well. And I also want to get from the court reporter to the answer as to whether or not Mr. Williams stated, no, I'm open carrying, or the testimony was, I'm open carrying from the officer. That to me makes a big difference.
Mr. Suckett,
Yeah, from Officer Sweaty, yes. So, I don't need much time. We can come back tomorrow.
What's today?
Today is Thursday.
Oh, okay.
Your Honor, I'm not back in the court tomorrow. Could you do it on Monday?
I will be there on Monday.
But hold on, just 1 second, let me just check real quick, so that's the fifth, what time?
Monday's
It's the sixth. Oh my God, look at all this stuff.
And this would also,
That's okay.
we, my office stays to also do my due diligence to research this as well. So I appreciate.
I can brief this issue and send it to the court as well as Madam Prosecutor. I have it right here. I have no problem, right? And then everybody can pull the case law out. I'm sorry, let me stand down when talking to the court. Judge, and I appreciate exactly what you're saying and what Madam Prosecutor is saying. This was such a hot button topic because the only reason I know is because one, I get alerts from the Supreme Court, all the courts actually, right, about new case law. Right, and I happen to be the president of the Bar Association, right? So we push this out. And most members, I'm just gonna say, are repulsed by that ruling, right? Because what that means is that there are gonna be more guns. More guns are not necessarily a good thing for, especially the Bar Association people. So I absolutely will brief it. I will send it to you. Okay. I guarantee you. That is the holding in Bruin. And it is a U.S. Supreme Court case. And as we know, that is the law of the land. And it's not partisan at all, I'm sure.
Now, I won't comment on that part.
Yeah.
But I do, I will welcome any briefing, but I still want to read it myself.
Absolutely.
I'll read it tonight. So you can come back Monday, Tuesday, whatever day, and
Monday or Tuesday?
we do 8:30, we can do the first thing in the morning.
Okay.
8 o'clock?
No.
Yeah, mom, you-
Listen, we can do, 9, how about 9? Let's see, I can check in and then run.
That's fine.
Over here.
So what day?
Monday or Tuesday.
What works? Is either one?
No,
I'm here
do
both
Monday,
days.
do Monday, got a doctor's appointment on Tuesday, I have to be fasting.
Okay, 9:30. We'll get all of our
Right.
PCCs out the way.
Or 10, whatever time, Judge, I'm good.
9:30, I like early.
9:30, I got you, Judge.
Okay, by that time I have.
We gotta come back on Monday at 9:30 for a decision, okay? You heard me, didn't you? All right, thank you.
This isn't normal. I usually make decisions on the spot, but there's a lot of case law that I want to read to make a decision, Mr. Williams, okay? Okay, so we're off the record on Mr. Williams.
Monday at 9:30, Your Honor, correct?
Correct. Mr. Pope, are you still waiting for us?
Hang up on.
What are you waiting for us now? He is patient.
Speaking so highly of you.
You don't understand that. I got a man on here too.
Oh.
I told her, yeah, I'm sending it to you. I need the card for Judge Sabree so I can send it to her email.
My car?
I need to,
You know
just
what?
send it to the email, just put it here.
Miss
What
Diallo,
is it?
it's kind of beat up, the one I got, 'cause I had.
Yeah, give me,
I
I'm,
got one.
Oh,
listen, give me,
mine
I
been-
think I used to make sure. Listen here.
Years.
Listen
It's
here.
on there.
Just,
There
you
you go.
have another one? 'Cause I-
Here you go.
And you already know mine, so you can.
I do,
CC
cause
me.
I sent you something, yeah.
Thank you.
Yeah, you know, working.
Something in the ring, girls, anyway.
It's all right.
Stop, man, stop. No, I'll get out the way.
Attorney Ryan.
I'm not gonna stop running on the grass. Shit.
Which piece is this for, Your Honor? It's for tomorrow, Chapel. You won't be here, so. Okay, Attorney Ryan, Attorney Polk, whoever wants to talk, let me know.
Is this the general?
Oh, you know what? I have you on mute. That's already on. Okay. It's AG's case.
Oh, okay. AG's case. Okay.
Are you there, Mr. Polk?
Yeah, I see you. All right. Okay, I can hear you, Attorney Ryan.
Thank you, Your Honor. Is Mr. Polk there?
He's driving, but.
Uh-oh.
So I saw in the notes, did you say that the date? Was 24th a good day for an adjournment?
Your Honor, we have been diligently working towards a possible resolution of this case to avoid an exam at all. And whatever date that was in the chat or the court was good with, or Mr. Polk wanted, was fine with me.
Okay, so February 24th at 10:30. I already
Okay.
put it in the system.
Okay, thank you. Do you need a step in order or is this sufficient?
That is sufficient. I spoke to both of you all and we're good. Clerk heard it too.
Okay, thank you so much, Your Honor. Have a good rest of your day.
You as well. Thank you.
Bye-bye.
Oh.